Good afternoon, esteemed conciliator. My name is Micko Vyver, and I represent Preen and Chang Administrative Law on behalf of our client, Mr. Andrew Abrahams. Today, I will address the natural justice grounds of review relevant to the decision to fine Mr. Abrahams for allegedly failing to participate in the 2024 census. The general circumstances of the dispute are as follows. Andrew Abrahams acknowledges the significance of the national census as a crucial planning instrument. However, he is profoundly opposed to the non-anonymous methods employed in the 2016 and 2021 census. Historically, the Australian census ensured anonymity by removing identifying material immediately. In contrast, the recent census have linked personal data to individuals via an identity key, thereby heightening privacy concerns. In 2017, Andrew's grandfather, a survivor of a concentration camp, extracted the solemn promise from the family to abstain from participating in any census, fearing the potential misuse of personal data. To honour this promise and remain compliant with the law, Andrew travelled to New Zealand and the Cook Islands during the 2024 census period, believing his absence from Australia on census night exempted him from the obligation to complete the census form. Despite this, Andrew received a demand to complete the form and subsequently a fine for non-compliance. He duly explained his absence to the census office. Nonetheless, enforcement actions were initiated against him. We are here to review this decision on the grounds of natural justice. The decision against Andrew Abrahams was procedurally flawed and breached natural justice for several reasons. Firstly, the lack of a fair hearing. Andrew's explanations and legal position regarding his absence from Australia on census night were not afforded due consideration. The principle of natural justice mandates that an individual must be given a fair hearing. This means that a decision maker must listen to all relevant information and arguments before making a decision. In Andrew's case, his detailed explanation and evidence regarding his travel during the census period were summarily dismissed. The refusal to properly consider his circumstances and the legal basis for his actions represents a serious breach of this fundamental principle of natural justice. The case authority for this submission is Cooper and Wandsworth Board of Works, a case heard in 1863 in the 143rd edition of English Reports from that year, on page 414. Secondly, the evident bias and prejudgment towards Andrew from the agents of the Office of Census Participation Enforcement. Internal communications between census enforcement officers revealed a dismissive and prejudicial attitude towards Andrew's case. The use of derogatory terms such as idiots and the baseless assumptions about Andrew's objections underscore a profound lack of impartiality. These communications demonstrate that officers have prejudged Andrew's case without proper investigation. Such bias and preconceived notions prevent a fair and impartial consideration of the facts, thereby compromising the integrity of the decision-making process. This is actual bias, and the case authority for this submission is R. and Lee, ex parte Shaw. Finally, a failure to consider relevant information. Andrew provided concrete evidence of his travel to New Zealand and the Cook Islands during the census period. The pertinent information was disregarded, and the decision to fine him was made without acknowledging his lawful absence from Australia. Ignoring such critical information not only undermines the accuracy of the decision, but also violates the principle of natural justice that requires all relevant evidence to be considered. The refusal to take into account Andrew's documented absence on census night highlights a significant procedural flaw. The case authority for this submission is Communications Union and Abbey Group. The relevant statute and case law. To substantiate our case, we refer to the following statutes and case law. Census and Statistics Act 1905. This act stipulates that individuals present in Australia on census night must participate in the census. Since Andrew was not in Australia, he should not be held liable for non-compliance. The legislation is clear that the obligation to complete the census is contingent upon being present in the country on the specified night. Andrew's absence from Australia legally exempts him from this requirement. Administrative Decisions Judicial Review Act 1977. This act facilitates the judicial review of administrative decisions and outlines grounds for review, including breaches of natural justice. The decisions against Andrew fails to meet these criteria due to a lack of a fair hearing and apparent bias. Under this Act, a decision that is made without giving a person a fair opportunity to present their case or is influenced by bias is subject to review and can be overturned. Privacy Act 1988. This Act governs the handling of personal information and incorporates the provisions to safeguard individual privacy, a central concern in Andrew's case regarding the confidentiality of census data. The linkage of census data to personal identifiers without adequate safeguards raises serious privacy concerns. Andrew's objections to participating in a non-anonymous census is grounded for legitimate privacy considerations protected by this Act. Keogh and West. The High Court case underscores the necessity for procedural fairness in administrative decisions. The decision against Andrew did not meet this standard, as his absence and explanations were not duly considered. Keogh and West establishes that a fair decision-making process must include the consideration of all relevant submissions made by the affected individual. Annette and McCann. This case reinforces the requirement for a fair hearing and the consideration of relevant material in administrative decisions. The refusal to appropriately consider Andrew's absence contravenes this principle. Annette and McCann highlights the procedural fairness is integral to ensuring justice and equity in administrative decisions. The proposed resolution. To rectify this situation, the following actions are proposed. Firstly, rescinding the fine. The fine imposed on Andrew should be immediately rescinded as it was based on an unfair and biased decision-making process, inconsistent with the principles of natural justice outlined in the ADJR Act. Review procedure. Implement a comprehensive review of the decision-making process within the Census Office to ensure fair hearings and impartiality in future cases. Officers should receive training on the principles of natural justice as reinforced by Keogh and West. Public clarification. Issue a public clarification on the requirements for census participation, specifically addressing situations where individuals are not in Australia on census night to prevent similar disputes. This step will align with the transparency principles embodied in the Privacy Act. Overall, by taking these steps, the Census Office can uphold the principles of natural justice, ensure equitable treatment, and maintain public confidence in the census process. We urge the conciliator to consider these points meticulously and to ensure that the justice is duly served for our client, Mr. Andrew Abrahams. Thank you.